And Hazel, how is Sepo?
He's okay.
That's very good. That's very good. Okay, let me bring up the part that we have been looking at so that we can pick it up from there. So we have been working with the definition of judicial review arising from the definition of administrative law. Yeah. So let's just bring up that definition of judicial review, members. Just bear with me 1 minute. Okay. Members, is anyone going to be kind enough to guide us on where we ended the last lecture we had? Members, anyone to be kind enough to guide us on the last lecture we had, members, where we ended?
So we were looking at the grounds of judicial review. We had looked at illegality, and we're now looking at procedural impropriety.
Okay. Thank you very much, Nompumelelo there. So we are looking at the grounds on which an application for judicial review can basically be brought before the High Court. And Nompumelelo has just told us that we are now supposed to be looking at the aspect of procedural impropriety. So we looked at illegality, and we gave case law on the subject of illegality. We looked at the case of Fulham Corporation, or Attorney General versus Fulham Corporation, and also the case of William Harrington versus Dora Silia. We are now supposed to be looking at the case or the ground of procedural impropriety. And on that ground, of course, there is a case equally that we shall be looking at to illustrate how the ground of procedural impropriety basically works. Now, I think I mentioned last week or the week last we met, I mentioned that the term procedural impropriety is derived from two terms. One is procedure, and then the other is improper. Now, in the governance of a country, in public administration, when decisions are being made by the executive wing of the government, being the public administrators, whatever decisions that they make are being or are prescribed, the manner in which those decisions are to be made, the procedures are actually prescribed by law. It is in line with what the law basically is. We say that the law is basically a tool of social control. And as such, there are two facets to law. One, we said, among other, is that the law prescribes. It has a prescriptive attribute to it, where it prescribes the manner in which certain decisions must be arrived at. It also prescribes the manner in which certain powers that are exercised by public administrative bodies or public officers. The law prescribes the manner in which or the powers and how those powers ought to be exercised by public administrative bodies or by public officers. So when we speak about procedural impropriety, it is with regard to the procedures. It is with regard to the procedures that would basically have been prescribed by law in terms of how certain decisions, in terms of how certain decisions ought to be arrived at by these bodies or individuals exercising a public function, how that they ought to exercise those functions. So when we speak about procedural impropriety, therefore, we are simply talking about instances where a public body or an individual performing a public function exercises certain functions or power, but then fails to adhere to the procedures as are laid out, fails to adhere to the procedures as are laid out by law. We therefore say that that person or body will have acted procedurally improper, hence procedural impropriety, hence procedural impropriety. So we are going to look at what then happens when a person has acted procedurally improper. But I think we did look at that, members, if I'm not mistaken. Guide me if I'm wrong, but I think we did look at that when we are looking at the case of Bedford Chilufya Kangombe. Are you able to confirm whether if we did or we didn't, members?
Yes, we looked at it, sir. The case of
So,
Bedford Chilufya Kangombe versus the Attorney.
Yes. So it means that we have looked at the ground of illegality, and we have also looked at the ground of procedural impropriety. Now, in this case of procedural impropriety, it brings out one very, very important point. There is always this view that a president is immune from legal actions, that you can't sue a president. 100% correct. You can't sue a president in criminal matters. Neither can you sue a president in civil matters. However, remember that what we are looking at here is not a legal suit in the ordinary sense. What we are looking at here is an application where it is the contention of the applicant that there is illegality. It is the contention of the applicant that there is impropriety in terms of procedure. It is also the contention of the applicant that there is unreasonableness or irrationality. Now, that is not a legal suit. It's an application. And all you are doing is to ask the court to do a review, hence the term judicial review, to do a review into the decision-making process to see whether or not the decision maker has somehow or somewhat acted ultra vires. On what basis? Illegality, impropriety, irrationality, or Wensbury unreasonableness. So a president, as the case of Bedford Chiluthia Kangombe now tells us a president is as much prone. The president is not immune, but the president is as much prone or subject of judicial review. They are very much amenable to judicial review. We saw how in the Bedford Chiluthia Kangombe case, the decision of President Kenneth Kaunda to dismiss summarily Mr. Bedford Chiluthia without having followed the correct procedures as had been laid out, then where first the requirement was that the teaching service should initiate investigations against the subject, which is basically Mr. Kangombe, and requiring that a tribunal is set up by the Teaching Service Commission, which Teaching Service Commission should then investigate the alleged malfeasance of Mr. Kangombe, and upon establishing the malfeasance leveled against Mr. Kangombe, then a recommendation presented to the president that the president should then dismiss Mr. Kangombe. But you recall from the facts we read in the case, Mr. Kangombe was exonerated by the Teaching Service Commission Tribunal. They said, we have not found the allegations leveled against Mr. Kangombe to be substantiated. And as such, therefore, our recommendation is that Mr. Kangombe be reinstated to his original position as deputy head of a school in the Copper Belt where he taught, or if the government is not pleased with him being there, the government should reinstate him and send him to the ministry headquarters where he can then be monitored to make sure that he is not doing that which he is alleged to be doing. And the Teaching Service Commission made that ruling, the tribunal by the Teaching Service Commission made that ruling, which ruling was not very much pleasing to then Secretary to the Cabinet, Mr. Aaron Milner, and also to the then Ministry of Education Permanent Secretary, who then Mr. Aaron Milner wrote to the President, Kenneth Kaunda, and saying that according to me, that is Mr. Aaron Milner now, according to me, this gentleman's journey in the public service has come to an end, and therefore I request Your Excellency to write, using your powers, to write and have this gentleman relieved of his duties from the public service. And the president did just that. And Mr. Kangombe was dismissed from the teaching service. But of course, the dismissal was said to have contravened the procedures provided by law for the dismissal of someone working in the Teaching Service Commission. His Lordship, Mr. Anel Sirungwe, by way of judicial review, ruled that the actions of the president were basically ultra vires. Procedurally, they were not okay. And ordinarily, there should have been an order of specific relief. There should have been an order of specific relief. There should have been a specific relief ordered by His Lordship, Mr. Justice Anel Sirungwe, which specific relief was not done. Now, I don't know if that is the homework that I had given. I think, to my recollection, I don't know why I feel or think that I must have somehow given the class some assignment to go and do on this subject. I don't know. Did I do that?
You said we should look at the decision and the rationale of the case. You're saying we should look at the reasoning, which is the rationale of the decision of the case.
In the case of Kangombe, yes?
Yes, sir. Yes, sir.
Yes, very good, very good. I had a very, very strong feeling that I had given an assignment to the class to go and look at something. So, His Lordship ruled that the actions of His Excellency, Mr. President Kenneth Kaunda, were ultra virus because they did not go in line with the prescribed procedures for dismissing someone. All right. So, members, what were your findings from your research? From the research that you made, what were your findings, members? Anyone can come in. From the research that we did, what were our findings, members? Anyone? Is anyone going to take the lead, members? What were the findings?
Okay, sir. I found out that the teaching commission's statute was unconstitutional because it was going against human rights, against the human rights, and secondly, that no one without the instruction of the president can uh, fire someone. Yeah, something along those lines.
Yes, Nompumelelo, you are finished.
Yes, sir.
All right. Are you sure, Nompumelelo, there was an issue of human rights that was raised in that case? Nompumelelo?
I think so. From my reading, sir, I think I saw something along those lines.
Okay. All right. All right. So Nompumelelo says that his lordship found that there were issues of human rights that arose in that case. What do the other members? What were your findings? Your research members. What did your research review? Other members, what did your research review? Nicolette, Richard, Angel, and Hazel. Anyone can come in. Members, Angel, Nicolette, Richard, Hazel, any one of us can come in. What was the issue? What was the decision of His Lordship, and what was the rationale behind that decision? Members, are you able to hear me clearly? Members, am I audible enough? Angel, are you able to hear me? Hello, Nicolette, are you able to hear me?
We're able to hear you, sir.
You are able to hear me. Okay.
Yes.
All right. So what do you say then? Hazel, what do you say? Angel, what do you say? Nicolette and Richard?
So, can I correct when I say human rights? It is
Yes, please.
constitutional rights.
Yes, please. You can go ahead.
I wanted to correct where I said it highlighted because human rights. It highlighted constitutional rights.
Nompumelelo, you are saying?
instead of human rights, it highlighted constitutional rights.
Okay, what constitutional right was that, Nompumelelo? Hello, Nompumelelo. What constitutional right was that?
That that the government has to act in accordance to the constitution.
Okay. Okay. All right. So let's look at the case. Let us look at the case on the issue of impropriety, so that as we are speaking, basically, we are speaking exactly the issues that His Lordship was actually addressing in there. So it shows that we probably, perhaps not even probably, but most likely, that we may not have read the case, which of course is not a very, very good thing, because we were all supposed to have read the case. So let us look at the case. Just bear with me here. I'm just getting to where the case is now. Procedural impropriety. Okay. I'm looking at the case from administrative law and process here, so that we can look at that. So the case of Kangombe is an authoritative case. The case of Kangombe is basically an authoritative case when we look at the issue of procedural impropriety. Why I especially like that case is simply because it also now, tells us that there is absolutely no immunity for a president. You may be a president, but you shall still be subject to the law, and you will be expected to actually act in accordance with the procedures as laid down in the law. And that should you go contrary to that, you shall be brought in line by way of judicial review. And when that is done, shall not be said, that you have immunity as a president. No, because a president is also basically supposed to act in line with the provisions of the law. So let us look at, let me just bring up on the screen our book here, Administrative Law and Process, so that we are able to see what His Lordship, Mr. Justice Anel Silungwe, basically said in that case, when he found that the president had actually acted ultra vires. On what basis was that finding actually made? So we are here. Okay, so the issue of procedure equally came for consideration in Kangombe. I don't know, did we read this last week? Did we read this, members?
I don't think so.
We don't think
I don't
so.
think
Yeah.
so, sir.
Okay, we don't think so. Okay, very good. If we didn't read that, then let's look at this. We're not going to read everything, of course, in the interest of time, but I'm not going to be the one reading. I'll let you go through. And the reason why I'm letting you go through, because I know that sometimes as students, we do not get to read. We may be told to read this, but we then overlook reading that. And yet that is where the information that we actually need would be found. So I'll be scrolling up. You tell me When you finish reading this passage, you tell me. You finish reading this passage, you tell me, and then from there you shall be able to see what the issues, in fact, in the case were. So we are talking about procedural impropriety. It had been considered in the case of Katongola versus the people in 1972. But like I mentioned, the authoritative case is a case of Bedford Kangombe, popularly known as the Kangombe case versus the Attorney General. So it is Kangombe who brought an application for judicial review against the decision of a president to dismiss him. So the facts are here. The facts are here. You know, the facts are all here. Now, from the facts, his lordship made this judgment here. And it is in here where the rationale behind the judgment actually is. So it's quite a lengthy judgment. But as said, these judgments are always very long, and it is in the detail where you actually find the law. So it ends here. So we shall read the judgment basically from shall read the judgment from here. You know, we shall read from here. From here. So we shall read these passages here up to there. Okay, so but for now, let us look at the brief facts of a case as highlighted here. So let's read from there up to here. I'll then scroll up from here so that we can continue reading. So read where I'm going to highlight here. When you finish, then I'll highlight the other part. All right, you can please read. When you finish reading this passage, you let me know so that I can scroll up. Huh?
I think you can scroll, sir. Can scroll, sir.
I'm not saying anything at the moment, Angel. Yeah, you are just reading. My mic is actually muted, huh? So you are just reading what I'm scrolling so that we have a discussion. Yeah, nothing is being said. Okay, we have all finished, huh? Okay, let's see what Hazel is saying here. Hazel is asking a question in the chat box. Let's see what Hazel is asking here. Hazel asks the question, so for any decision that is taken on the president's behalf by the Teaching Service Commission cannot be declared void by the president himself. No, of course, Hazel, the president cannot overturn. Otherwise, then it defeats the purpose. It defeats the purpose if the president is to be given the power to overturn a decision that has been taken on his behalf. Yeah, to be given the authority to do that. To give the president to do that basically means that you are actually defeating the whole idea and purpose. You are defeating the whole idea and purpose of delegating, because that is now a delegated function. But what we see from what His Lordship's judgment is telling us, before the Teaching Service Commission made the decision, when they were still in the process of making the decision, if the president saw that they were heading in the direction he may not agree with himself before they actually arrived at the decision, but that is before they actually arrived at the decision. If they were heading in a direction he may not have agreed with, what we are being told here is that the president actually had the power to suspend the exercise and to have himself make the decision. But that did not actually happen because the Teaching Service Commission Tribunal had already exhausted, they had already made the decision all the way to the end. And therefore, the powers of the president to suspend their decision-making process in this matter, according to His Lordship, had basically been overtaken by events, and therefore the president could not have made any other decision than what the Teaching Service Commission Tribunal had actually decided. So this matter, like I have been saying, is a classical case on issues to do with procedural impropriety. Now, there is a question that I always like to ask in this regard. The question is, when you look at the relief that is available when an application is based on procedural impropriety, the relief that is available is that known as an order of mandamus, an order of mandamus. Now, we learned the last meeting we had that an order of mandamus, also known as a mandatory order, is basically an order that is granted in private law, known as an order of specific performance, meaning in the law of contract, which you guys have been doing this semester, the court is going to make an order of specific performance, meaning it will require a body to, or an individual rather, in a contract to act as expected according to the contractual agreement. So every party to a contract is obliged, arising from the agreement made in the contract, to act. Any failure to act without justifiable cause. Yes, Hazel?
Oh, sorry, sir. I thought maybe I should let you continue before asking the question.
That's
but
fine.
I'm just
You can ask.
I'm just confused why the mandatory order, mandamus, would be the one that they go for instead of the quashing order.
Okay, that's very good. That's very, very good. That's a very good question, Hazel. We shall come to that. So we are saying that the order of specific performance compels a party to a contract to act as expected from the contract. An order of mandamus, on the other hand, in public law, mandates you to act in accordance with the procedures as laid down in the law, so that if you act in any way that is not in line with the procedures, the court, once they establish, now, here's all this answers your question here. Once the court establishes that your actions did not align with the procedures as laid down in the law, they do not quash the decision you make. They will just say that you acted improperly according to the prescribed procedures as laid down in the law. In effect, they are saying that your decision is not valid. So rather than looking at the decision that you have made, because remember, we have been saying that judicial review is not so much about the decision that has been made, but the process leading basically leading to the decision. So in this case, equally, it was not so much the decision that was faulted. What was faulted was the manner the decision was arrived at, that the person who actually took the decision according to the procedure was not the person that was supposed to make the decision. So there was no way they could have quashed the decision, because the procedure itself showed that the decision was a nullity. So once you establish as a matter of fact that the procedures were not followed in accordance with the law, right from the word go, the decision equally stands down. So now the order that the court in such instances would be required to make is what is known as a mandatory order, or an order of mandamus. Now, what does the order of mandamus require? The order of mandamus requires you now to go back to the drawing board and start making the decision, but this time around requiring you to follow the procedures as has been laid down in the law. This time around to follow the procedures as has been laid down in the law. Same as in the contract, you are now mandated to act as the contract basically requires you to act. That is an order of specific performance. In the case of public law, it is an order of mandamus where you are now mandated. You have been mandated to act as the law stipulates or requires you or prescribes that you should basically act. So now, the question is, if the court had made a finding of fact that there was an error in terms of procedure, why didn't the court make an order of mandamus against the president? That's the question, members. If it had been established as a matter of fact that there was an aspect of ultra-virus arising from procedural impropriety, which then should have attracted an order of mandamus, meaning requiring the decision maker to go back to the drawing board and start the process of making the decision, but only requiring that this time around the decision should be made in accordance with the procedures as stipulated. The question is, why didn't the court actually make this order of mandamus in the case of Kangombe against President KK? Yes, that's a thought now, isn't it, Hazel? Why do you think the court did not make that order of mandamus? Anyone can come in, members? Hazel, Nkomo, Mpumelelo, and Richard. Any one of us can come in. Anyone to give it a try, members? So it's a question. We need to answer it. Okay, Hazel says she has no idea there. Richard and Nompumelelo, what do we think? Why didn't the court make an order of mandamus in this case? Members, why didn't the court make an order of mandamus in this case?
Can I try, sir?
Yes, you can try.
Okay, so we say the order of mandamus, it mandates you to act in accordance to the law. So it means that you have to go back and redecide following procedures as laid down in law. So they couldn't give the president this order because initially he was not the one who was supposed to make the decision.
Yeah,
so that's why
that is 100%. That is the answer. Basically, to have made an order of mandamus against the president would have in effect basically been in effect giving power to the president that he did not have. He did not have the power to exercise that function that he exercised. So to have made an order would have been now to allow him the process that had already been done by the Teaching Service Commission Tribunal. And of course, then you would have given him the power to dismiss Mr. Kangombe, contrary to the findings of the Teaching Service Commission Tribunal that had exonerated Mr. Kangombe. So 100%, the president did not have the power. You can only order mandamus against a body that makes a decision, and it actually has the power to make the decision that it makes. If it does not have the power to make the decision that it makes, and then you tell it to say, go back now. You acted wrongly. Initially, you acted wrongly because you didn't follow the procedure. But now we are mandating you to go back to the drawing board and ensure that this time around you follow the laid down procedures as contained in the law. In effect, you are giving power to a body or a person that doesn't actually have the power to exercise that function. Okay, so that is about procedural impropriety. And like I said, this case is classicus because it is now telling us that, you know, a president cannot be immune from judicial review. This case is telling us that a president cannot be immune from judicial review. Yes, the president can be immune from legal suits, but cannot be immune from an application for judicial review. In line with that statement, I would like you to take down the name of the case I'm going to give you right now. This is a case of R versus Medical Appeals Tribunal, ex parte Gilmore. The case of R versus Medical Appeals Tribunal, ex parte Gilmore. That case is an interesting case on the aspect of exemptions from judicial review. Go and read that case and see what Lord Denning, go and read that case and see what Lord Denning's view was on the aspect of exempting certain bodies from appeals, and whether exempting certain bodies from appeals also meant exempting them from review by way of judicial review. Yes, Mampumelelo?
And please come again. It's ex parte what?
Ex parte Gilmore, Gilmore, Gilmore. R versus Medical Appeals Tribunal, R versus Medical Appeals Tribunal, ex parte Gilmore. That case basically tells us about exemption clauses, where tribunals, you know, a tribunal makes a finding, or a tribunal is established under an act of parliament, and the act of parliament says that the decisions to be made by this tribunal shall be final, meaning shall not be subject of any appeal. Now, in that case, a matter came up where the issue was not so much of an appeal, but an application for judicial review. It came before His Lordship, Mr. Justice Lord Denning, who then interrogated what the meaning of without, or not without, but the meaning of exemption clauses, where a decision of a tribunal would be exempt from any appeal. So when an application for judicial review was brought against the Medical Appeals Tribunal, they wished to rely on an exemption clause that was in an act of parliament that established that tribunal. And they said, according to the act, when the decision of the Medical Appeals Tribunal is made, that decision is final and is not subject to appeal. So now, Lord Denning was to consider that issue in an application for judicial review, because that was now an application for judicial review and not an appeal. So when the application went, counsel for the tribunal argued that they were immune from an appeal, but they failed to distinguish that it was not in fact an appeal that had gone before the court, but an application for judicial review. So when you look at that case, you will see how His Lordship Denning, you know, how so skillfully he made the decision to say, yes, tribunals may be exempt or immune from an appeal if there is express provisions in the law that basically immunes them from an appeal. However, his lordship said there is no way they can be immune from review, because where there is a blatant disregard of procedure, or where there is blatant ultra-virus conduct on the part of that body, in the course of it arriving at a decision, not the decision itself, but in the course of it arriving at a decision, there is ultra-virus. Lord Denning said that such cannot therefore be exempted from review. Yes, they may be exempted from an appeal, but may not necessarily be exempted from a review. So equally, when you talk about a president shall be immune from legal actions, legal suits. A president shall be immune. However, a president cannot be immune from proceedings by way of judicial review. And that is the case of Kangombe. That is what the case of Kangombe basically is telling us, among other things. Okay, that's very good. We have read the case. So in conclusion, let me just wind up. And say something here. Yes, Richard, you can come in, Richard.
Good afternoon, sir.
Good afternoon, Richard, and how are you? Oh, it's morning. It's
okay,
still
sir.
morning, actually, Richard.
Oh, it's morning, eh?
Yes, yes.
It's a bit hot in Copperbelt, so I thought this afternoon.
Okay.
Okay, yeah, just a simple question, sir. I'm trying to look at the case of the 3 constitutional judges that were dismissed by the president. Now, in an event that, for example, if there will be discovery that there was a procedural impropriety in that dismissal, and then
sorry, Richard, we can't hear you anymore. Hello, Richard. You at some point we stopped hearing you. Are you able to repeat what you were asking, please? Hello, Richard. Are you able to hear us? I'm sure Richard is facing challenges. If you are not able to speak, Richard, you can just ask that question in the chat box. It seems like an important question that we should really be able to hear and have an opportunity to say something about. So if you are able to hear me, Richard, kindly type in. If you can't, oh, okay, I think Richard was having challenges there, and now he has is dropped off. Okay, let me read in summary. He says the court's decision highlights. Okay, Richard is back. Okay, Richard, welcome back. We would really like you to finish the point that you are making, Richard. So if you are able to come back, kindly come back and just ask that question. If you are having challenges with the mic, you can still type the question. We would really love to hear that question so that we can make comment on that question. Richard, are you able to come in? Okay, too very bad about that. If you can't hear me, Richard, that's too very, very bad. But if you are able to hear me, kindly write down the question in the chat box. Okay, so let me just read here. The court's decision highlights the need for adherence to the law and procedures that, or procedures rather, set therein at all levels of power in the governance of the country. As a constitutional provision, where all persons are bound by the Constitution and laws made pursuant to it, it becomes ultra-virus for anyone at whatever level of governance to disregard the law without legal redress being available, and by so doing, the doctrine of rule of law and good governance are promoted. Justice Silungwe decided not to concern himself with the issues of breach of the rules of natural justice, where the applicant contended that he had not been given an opportunity to be heard, thereby breaching the Audi altering pattern rule. However, a close consideration of the matter, in fact, indicates his lordship's decision to be correct, as the applicant had in fact been heard by the tribunal set up by the Teaching Commission Service, which found the allegations leveled against the applicant to have been unsubstantiated. Equally, the court could not make any order in terms of mandamus requiring the exercise of powers in line with the procedures, as that had already been undertaken by the tribunal, which cleared the applicant and had already recommended the reinstatement of the applicant or his transfer, a decision the court further upheld. Ridge, let me just go up. Ridge is equally quite instructive on the issue of procedural fairness. The applicant, a chief constable, okay, anyway, we can't read that because we haven't dwelled into that case, so we shall leave it for you to read at your own time. What I would like us to do now is to go to the next ground, which is procedural fairness. Go to the next ground, which is procedural fairness. Yes, Richard, are you back now? No? Okay. Yes, Richard is back. Yes, Richard,
sir.
would you like to ask a question now?
Yes, I lost coverage. Sorry, I'm back online now.
Yes, Richard,
Yes,
you can come in.
So my question was with reference to our 3 constitutional judges that were dismissed by the president. So now, what would happen, for example, if the court, let's say they appeal and then the court discovered that there was a procedure impropriety in their dismissal, and then in the interim, the president maybe appoints, and then that's discovered from the court. So what would happen to those 3 that have already been dismissed? Would they still be reinstated, or they'll just do positions like that?
Okay. All right. Thank you very much. First and foremost, we need to take note of the fact that the judges have actually sought judicial review already. And we are just yet to hear the outcome of the application now. What judicial review does, when you make an application for judicial review, automatically it works as a stay of proceedings, meaning it works as an injunction. It stops the process of proceeding with the removal of the judges until the issues raised by the 3 judges have been dealt with by way of judicial review. So they have challenged the dismissal or their suspension. They have challenged their suspension to be ultra-virus. So if their application for judicial review is upheld, if it is established that indeed there was ultra-virus conduct in the president's decision or action to suspend them, then they will have to definitely be reinstated. But remember that the president acted pursuant to the recommendations of the Judicial Service or Judicial Complaints Commission. So what happens here in this instance is that the application for judicial review is not only challenging the decision of the president to suspend. The application for judicial review is a broader application looking at where the recommendation to actually suspend came from. the Judicial Complaints Authority or Commission. So once it is established by way of judicial review that indeed the recommendation for suspension was ultra-virus, then the 3 judges most definitely will have to be reinstated, because remember that the president's resuspension is pursuant or is in accordance or is arrived at from the recommendation of a judicial complaints commission. So once the judicial review application establishes that the recommendation was ultra-virus done, then the suspension itself shall be null and void. And once it is established, then the 3 judges most definitely will have to be reinstated. So, Richard, that is the position. I don't know if we have addressed the question.
Yes, sir. Thank you. It's very clear.
Okay. All right, Richard. Thank you very much. So now, let us go to the other ground on which an application for judicial review can actually be brought. Now, this is an interesting ground, members, known as irrationality or unreasonableness, but this unreasonableness is in the Wensbury sense. So the word so much is not Wensbury, but the word so much is unreasonable. Only that this unreasonableness should be as had been established in the case of Wensbury Association. So the word is either irrationality or unreasonableness. The word is either irrationality or unreasonableness. So these 2 terms mean one and the same thing. When you are being irrational, you are being unreasonable. Now, this unreasonableness must be in the Wensbury sense, meaning as had been established in the case of Associated Provincial Picture Houses versus Wensbury Corporation. Associated Provincial Picture Houses versus Wensbury Corporation. Now, this case, members, is such an interesting case. The case of Wensbury Corporation is such an interesting case. This case has...
Wensbury.
Hello, Nampumelelo. Oh,
Please spell the Wensbury.
sorry?
Spell the Wensbury, as in it's Wednesbury.
It's there. It's there on the screen where I'm sharing. This is the word here.
Okay, so thank you.
Okay. All right. So the case of Associated Provincial Picture Houses Limited versus Wensbury Corporation set up what is known as the objective test in determining whether indeed the actions of a public body or an individual exercising a public function is indeed irrational or is unreasonable. But this unreasonableness is that which was established in the case of Associated Provincial Picture Houses versus Wensbury Corporation, hence being known as Wensbury unreasonableness or unreasonableness in the Wensbury sense. So unreasonableness in the Wensbury sense. Now, what happened in this case? Very interesting. A law had been passed. A law had been passed. In fact, 2 pieces of laws had been passed in the United Kingdom. One of the pieces of law gave power to local authorities. So Wensbury Corporation, by the way, is a local or was a local authority, a council. So the law gave power to local authorities to come up with regulations, which regulations were to guide the manner in which cinemas were to operate within the jurisdiction of these local authorities. Of particular interest was a provision in the law known as the Cinematography Act, and the other one, the Sunday Entertainment Act. So in the Cinematography Act, it gave power to local authorities to regulate the manner in which cinemas were to allow, or local authorities were to allow cinemas to operate within their jurisdictions. The other law, the Sunday Entertainment Act, gave authority to local authorities to determine the opening and closing of cinemas operating within their jurisdictions, but not only the opening and closing times, but also individuals that could be admitted as patrons in cinemas operating within the jurisdiction of these local authorities. So Waynesbury Corporation, a local authority, for whatever reason, not being made part of the facts, passed a law, a bylaw, a regulation, which stated that any person below the age of 16 passed a regulation stating that any person below the age of 16 could not be allowed entry into cinema houses operating within the jurisdiction of Waynesbury Corporation, whether they were accompanied by an adult or they were on their own. As long as they were below the age of 16, they basically were not to be allowed admission or entry into cinema houses operating within the jurisdiction of Waynesbury Corporation. Now, Associated Provincial Picture Houses Limited was a company in the business of running cinemas. So now, they thought and believed that the decision by Waynesbury Corporation was irrational or unreasonable. They contended that a rational person or a reasonable person could not, in fact, have arrived at the decision that they arrived at, having taken into account all factors into consideration. A reasonable person could not have arrived at the decision. In fact, it was contended that the decision that Waynesbury Corporation arrived at was so outrageous. That was the submission made by Associated Provincial Picture Houses, that the decision made by by Waynesbury Corporation was so outrageous in its defiance of logic that a reasonable person could not, in fact, have arrived at that decision. That a reasonable person could not have arrived at that decision. Now, what does unreasonableness mean? What brings about unreasonableness? The court had to consider that before we even start talking about the contentions by Associated Provincial Picture Houses. What does the meaning, what does the term unreasonable mean? So in the court, in the case, the court had to consider what the meaning of unreasonableness is. The court said unreasonableness is an instance where a public body or a public decision maker takes into account certain trifles, certain trivial considerations in the course of making their decision. they take into account certain trifles that a reasonable person or being would not have taken into consideration what they took into account. And that because they took into account those trifles, they have ended up arriving at a decision that is so irrational or so unreasonable that a reasonable person or body could not in fact have arrived at, or failing to take into account certain important consideration as they make their decision. They omit to take into account certain important considerations that a reasonable person could not have omitted to do that, that by the fact that they omitted to do that, they have arrived at a decision that is so irrational or unreasonable that a reasonable person or body could not in fact have arrived at. Now, when you look at that, what it is telling us here is that there is this word that keeps on coming up. The word of reasonable person could not have arrived at. So it means that if you arrive at that, which a reasonable person could not have arrived at, it means that you are being unreasonable. What makes you to be unreasonable basically is because you took into account certain trifles in the course of making your decision that a reasonable person or body could not have taken into account, or that you have failed to take into account certain important considerations in arriving at a decision that because of your omission to take into account certain important considerations, you have arrived at a decision that a reasonable person who would have taken into account what you omitted to take into account would not have actually arrived at the decision that you have arrived at, and therefore the decision that you have arrived at being considered to be irrational or unreasonable. So now, in the case at hand, Associated Provincial Picture Houses versus Waynesbury Corporation, the contention of the cinema house was that the decision by Waynesbury Corporation was so irrational, so unreasonable in its defiance of logic that a reasonable person would not have arrived at the same decision. So now the question is, what is it that Waynesbury Corporation took into account when they made the decision to say any person below the age of 16 would not be allowed admission into cinema houses operating within Waynesbury Corporation? What was it that prompted them to take into account that, which that thing would be construed to be a trifle that a reasonable person or body would not in fact have taken into account that? Or perhaps what did they omit to take into account that a reasonable person or body would not have omitted, and that because they omitted, they have therefore arrived at a decision that a reasonable person would not have actually arrived at? Now, in this case, members, what the court is trying to tell us is that it is not the job of a court to say what is reasonable or what is unreasonable. It is not for the court to say what is a trifle and what isn't, that a reasonable body or person would not in fact have taken into account those trifles, that they then ended up arriving at the decision that they arrived at. The court recused itself, members, from that and said, no, we are not a competent body to say that these are trifles and these are not trifles, so that by this body taking into account or considering them, and it made its decision. Now, as the court say, we think you ought not to have taken into account that, or as the court now say, we think you should not have omitted to take into account that, so that by so doing, we then say that you acted therefore irrationally or unreasonably. So here now, the court is saying it is not us. It has to be another body that appreciates the functions that are performed by Waynesbury Corporation, meaning it has to be another body that has been given the authority to perform the function that Waynesbury Corporation has by law been given to perform. It is about asking that body, had you been the one faced with a situation that Waynesbury Corporation was faced with, would you have taken into account what they took into account when you are arriving at a decision? Or would you have omitted perhaps to take into account what perhaps ought to have been taken into account in arriving at the decision? So now, depending on the answer that this other body that has the same power to perform the functions that that Waynesbury Corporation had been given the power by law to perform, the answer that this body would give to the question, would you have acted the manner Waynesbury Corporation acted? Would you have omitted to act in the manner Waynesbury Corporation acted? The answer that the question will receive will then determine whether indeed the unreasonableness or irrationality occurred. So the court had to interrogate and ask this question to other bodies like Waynesbury Corporation. And if these other bodies would say, yes, we would not have taken into account what Waynesbury Corporation took into account, we think they went overboard, then the court at that point will be saying, then what this body is saying is that Waynesbury Corporation acted irrationally or unreasonably, hence the Waynesbury sense. Would you have omitted, would you have not omitted to take into account what Waynesbury Corporation omitted to take into account? If the body says we wouldn't have omitted because we think that that must have been one very important factor to consider in arriving at the decision, then the court would be saying what this body is saying, therefore, is that Waynesbury Corporation acted irrationally, Waynesbury Corporation acted unreasonably. So when we speak about Waynesbury Corporation or Waynesbury unreasonableness, when we speak about irrationality, it is not the court now. It is not as the case of illegality. It is not as the case of procedural impropriety, both of which are established or determined by the courts of law. Waynesbury Corporation, Waynesbury unreasonableness or irrationality is not at all determined by the courts of law, and the courts of law basically will recuse themselves from the temptation to hold that there was unreasonableness in the manner a body acted, or that there was irrationality in the manner a body acted. So the case of Waynesbury Corporation members established what is known as an objective test of what is reasonable or what is unreasonable. Members, this is something that you learned about in the first semester when you were looking at the law of torts, where there we learned about the Bolam test. I don't know if you remember the Bolam test. Do you remember the Bolam test, members? Does anyone remember the Bolam test? Okay, Nompumelelo remembers the Bolam test. Very good. I'm not going to ask questions on it because of time. So in the Bolam test, the Bolam test tells us that the standard of care is to be determined by a particular profession by a particular group of individuals belonging to a particular profession. But it cannot be the court to say, for instance, in a case of medical negligence, it cannot be a court, a judge, to say that a medical doctor acted negligently as he conducted or performed a procedure on a patient, because to do that means that the judge would be holding himself as an expert in the field of medicine. So the Bolam test requires that the profession of medicine, the regulatory body that regulates the profession of medicine, should basically be the one to say whether or not a medical doctor acted medically professional or not, whether there was proper care of or duty of care that had been discharged by a medical doctor in a case of medical negligence, for instance. So the principal, members, is not any different when it comes to public law, and you are looking at the case as had been decided in Associated Provincial Picture Houses versus Waynesbury Corporation. Okay, I'll leave it here, members. You should, in your own time, find time to read the details of this case of Associated Provincial Picture Houses versus Waynesbury Corporation. Okay, on Monday, we shall begin with specific reliefs and the grounds that attach to each specific relief. So we shall be looking at the specific reliefs available on an application for judicial review, depending on the ground. And then once we finish that, we shall then look at the next topic. I think the next topic should be, if I'm not mistaken, Judicial Code of Conduct. That is a topical issue right now, and that is what Richard was asking about. So we shall learn more, members, about that. We shall see also where the former president got the impetus to ask the 3 judges to recuse themselves. That is something that we shall discuss in detail when we start looking at the Judicial Code of Conduct. So we shall look at that next week on Monday. So for now, we call it a day. Enjoy yourselves. Although, you know, it is sad that we have a cold weather when we should be having a hot weather, which should signify the start or the beginning of a rain. I hope the weather can go back to its hotness, so that it gives us hope that rain shall soon start falling. But it's very cold. Richard, I don't know if it is as cold in the Copper Belt as well.
Not much today, sir. That's yesterday.
It was cold yesterday.
Today's relatively warm.
Yeah, it is very cold. Well, not very cold, but it is cold. Nothing that it should be when it is a rainy season, basically. Yeah. Okay, members, are there any questions? No questions from Hazel. No questions from Nompumelelo. Richard, do you have a question?
No questions, sir.
No questions from Richard either. Okay, members, we have come to the end of the lecture, and we shall have another lecture on Monday at the same time, 10:05, 10:10 to 12:05 or 12:10. Okay, enjoy the rest of the day, and do have a lovely Friday.
Thank you, you too.
Thank you very much. Enjoy the rest of the weekend.